We'll start the hearing. This is originating application 881 of 2023, summons 47 of 2024, Babel Holding Limited.
All right, good morning, Mr. Chan, Mr. Yeo, Ms. Yeo, and Ms. Lee, together with Mr. Izzat Rashad, for the applicants, correct?
Yes, Your Honor. Thank you.
All right, thank you. For various non-parties, Ms. Charlene Wee from Prolegis for GGC International, for GGC International and Genesis Global. Is that correct?
Yes, Your Honor, that's correct.
Thank you. Ms. Low for Zipmax Asia Private Limited, Zipmax Private Limited.
Yes, Your Honor. Thank you.
All right, thank you. Mr. Chan for Mr. Yang Cho.
Yes, Your Honor.
All right, and Mr. Fu for Parastate Labs, correct?
Yes, Your Honor. Thank you.
All right, let me and Mr. Zoom allocation first. So parties are reminded that there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings. And only those counsel or persons notified to the court should be present at each location, and parties should treat these proceedings as they would a physical hearing. All right, let me just sort out some other attendance matters first. I had an indication that Quantum Return International Limited was opposing, but we are supposed to have a foreign counsel on representing them, Mr. Clarence Chung. I just wanted to confirm your position this morning, Mr. Chung. Are you able to join us as a panelist? My manager will be extending an invitation to you again to join us as a panel so I can hear what the position is. Annie, could you invite Mr. Chung?
Yes. I've promoted
Your
you
Honor,
to panelist.
Your Honor, if it assists, we received an update from Quantum
Yes.
indicating that they would, while they do oppose the hearing today, they would not be making submissions.
All right. So thank you. All right, so Mr. Chung, we will not bring you up to the panel, but we just have it on record. You're opposing, but you're not. Quantum Return is not actually asking for arguments to be presented. All right, so I was a bit concerned about that since we don't seem to have local counsel on record. All right, so Mr. Chung will lead you in the public area. Sorry.
Yeah. So our position is opposing the sanction, but but we are not going to make any orals. Yeah.
Oral
Thank you.
submissions. All right, so I was wondering why there's no lawyer. All right, we'll bring you back down to the public area. Thank you, Mr. Chung. All right, and we also had a representative from another company, but I understand the representative is only listening in as well, although they indicated that the company is opposing. All right, then. All right, let's begin then, Mr. Yo. I believe you're having conduct this morning then?
Yes, Your Honor, except on a few discrete points if they should turn up, but we will try not to be a tag team here, Your Honor. Your Honor, very briefly, this is an application for, first of all, court sanction pursuant to section 210(4) of the Companies Act of a scheme arrangement. The scheme arrangement has been approved by the requisite majority of creditors already, but we still need to pass that final hurdle of court approval. And I humbly submit that we should get it. We have filed written submissions to that effect. May I check that Your Honor has that?
Yes. All right. All right. Before we get to the submission, because of the other issues, I'm a bit flustered. I think I may have forgotten to read my allocution. So let me just read it out for the record, just in case someone decides to do unauthorized photography today for some reason. All right, so parties are reminded that there is to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings. And only those counsel or persons notified to the court should be present at each location. Parties should treat these proceedings as they would a physical hearing. All right, sorry, Mr. Yo. Let me just answer your question. Yes, I have read through your submissions. You can focus on the main point this morning.
Certainly, I don't intend to do a point by point. The second thing, Your Honor, that we seek, Your Honor, is a declaration, if necessary, if the court should deem it necessary, that certain non-compliances with the proof of debt regulations, essentially to circulate or failing to circulate a list of creditors and an updated list of creditors, does not invalidate the scheme meeting or the scheme. And further, alternatively, in order that the period for the scheme chairman to comply with those requirements in the proof of debt regulations be extended to the 4th of January when it was in fact circulated.
Alright.
Your Honor, I will start first with the sanction application, and then I'll turn to the procedural irregularities later.
All right.
Your Honor, just to quickly jump to the factual update to Your Honor, that is at paragraph 8, page 5 of my submissions.
Mm-hmm. Yes.
This is the lead up. This is hopefully a very bullet pointed timeline for Your Honor. On the 6th of March, we first applied for moratorium protection that was granted on the 17th of April. On the 30th of August, we filed the convening application to give approval for the convening of scheme meetings. On the 9th of October, the court granted the scheme convening order, and inter alia granted the applicant leave to convene a single scheme meeting of one class of scheme creditors. We were required to do this by the 17th of December 2023, and we did in fact do so. Your Honor, just for Your Honor's convenience, we have shared on screen the paragraphs which I'm referring to.
Yes.
Now, notably, Your Honor, a creditor, Parastate Labs Inc., had objected to the convening application, and we have expressly set out the grounds of their objection in our written submissions, but I don't intend to go through them. Because in the end, Your Honor, I'm going to skip ahead to paragraph 13. The company sought to comply with the scheme timelines, and we pretty much met all of them. On the next page, Your Honor will see paragraph 14. The scheme managers circulated the notice of scheme meetings. Importantly, we received 105 proofs of debt. The scheme chairperson indicated that one of that was filed by a non-scheme creditor, Baker and McKenzie. They are not a scheme creditor because they are one of the advisors. The scheme chairman partially rejected 47 scheme creditors' claims for the reasons which they've set out in great detail, and we've annexed the full chairperson's report which details that. Furthermore, another creditor called Mr. Wang Li, Your Honor will recall, he had agreed not to submit a scheme claim. He is a former director of the company. Ultimately, it was assessed that 102 scheme creditors were eligible to attend and vote at the scheme meeting. Essentially, the persons who were excluded were Mr. Wang Li, who I've just gone through, Baker and McKenzie, who were held not to be a scheme creditor in the first place. And third is Mr. Flex Young, who has been filing the affidavits to date, Your Honor. So hopefully you've seen his name before. He is the current director of some of the Babel entities. And he had agreed not to vote at the scheme meeting, just to avoid any issues of class or any allegations that, you know, he's a related party and his vote should not be counted and so forth. So he agreed not to vote, and for that reason, the scheme chairperson held that he was not eligible to attend and vote at the scheme meeting. Your Honor, next update was that Parastate filed an appeal against the scheme convening order. But again, I don't intend to go into this in detail simply because that appeal was eventually withdrawn on the 13th of December, as Your Honor will see from paragraph 16. We then, on the 16th of November, sent the results of the chairman's adjudication of proofs of debt to every creditor. And that included a listing of all creditors and the amounts for which their claims had been adjudicated. On next point in the timeline is the 30th of November. Objections were received to the adjudications from 6 creditors by the last date for them to raise objections, and the appointed independent assessor, which in this case is Baker Television, assessed these objections. On the 4th of December, the scheme managers then circulated the next thing, which is notices for scheme creditors, proxy forms to be submitted. The next important point date is the 8th of December, which is after incorporating adjustments arising from the IA's determination on the objections received from creditors to the adjudications of proofs of debt, the chairperson then sent a revised adjudication result to all scheme creditors, again listing all the scheme creditors and the amounts for which they had been admitted. On the 9th of December, a supplemental X-plan was published and sent to all creditors, which contained a number of additional disclosures to assist the scheme creditors and the court. We've discussed this in detail in the previous moratorium extension hearing not too long ago, Your Honor. So hopefully creditors or the court does not need me to repeat the contents there. On the 14th of December, voting instructions were circulated. Long story short, Your Honor, I will cut ahead to paragraph 24 of my submissions. On the 17th of December at 8 p.m., that was the final date for the scheme company to hold the scheme meeting by, according to the revised timelines that had been approved by the court before. At 8 p.m. Singapore time, the scheme meeting was held via video conferencing on a Zoom platform. The scheme meeting was attended by 46 out of the total 102 scheme creditors that were eligible to attend and vote. That's about 45% in number. But if you look at value, Your Honor, the number goes up even higher. So the attendance, I'm not talking about voting yet, Your Honor, I'm just talking about attendance to satisfy Your Honor that the scheme meeting was hopefully representative and fair. In terms of value, Your Honor, 78.79% of scheme creditors attended the meeting. And again, all of these figures exclude Wang Li and Yang Zhou, or Flex Yang, as I called him earlier. Your Honor, next page, Your Honor will see, now this is raw numbers. I have not yet excluded related party creditors. I will come to that shortly, Your Honor. Raw numbers, 80.43% in number, representing 90.15% in value, present and voting, voted in support of the proposed scheme. Now, Your Honor, I promise to give Your Honor the reference for what happens if you exclude related party creditors. May I turn Your Honor's attention to page 20, paragraph 51.
Sorry, what?
Page 20, paragraph 51.
Sorry, I keep losing you at the start. What was the start of the reference?
Page 20, paragraph 51.
All right, thank you.
Your Honor, we disclosed on the 4th of January that the voting results, the raw numbers which I gave Your Honor earlier, included 6 possible related party creditors that may have voted at the scheme meeting. So what we've done in the next page, Your Honor, on page 21, is we've set out the position if you exclude the related party creditors. Now, of the 6, the applicant's position is that following the test in contributor and so forth, only 2 of the 6 should be excluded. And we've given the percentage, what I believe to be the defining percentage here, if you exclude those 2 related party creditors at paragraph 52. The percentage is 79.55% in number, representing 90.11% in value. However, what we did at paragraph 53 and 54 is we gave Your Honor essentially all the other 2 permutations, which is if you discount the vote of all 6 related party creditors, in fact, the percentages get better because 1 possible related party creditor voted against. But even in the worst case, if you discounted all the votes of the related party creditors who voted in favor of the scheme, but you included the vote of the related party creditor who voted against, we've given you the percentage in paragraph 54, Your Honor. Your Honor, my simple submission here is that regardless of which scenario we look at, in any of the above permutations, we have more than satisfied the test for number in value, for votes in number and vote majority in value. Your Honor, I do not intend to belabor the legal principles. I'm sure Your Honor knows it better than I. So if I may just jump to the sort of application to the facts, Your Honor.
Yes.
Your Honor, I'm going to jump to page 13 at paragraph 36. Your Honor, we flashed it on screen again, if convenient to Your Honor. First of all, hopefully there is no question by now that the Honorable Court has jurisdiction to sanction the scheme. The applicant is a company with the requisite standing to bring the convening application. I believe we have satisfied Your Honor of this at the previous convening application and at the previous moratorium applications that we had commenced before Your Honor. Second, Your Honor, paragraph 39, we submit that the Singapore courts have subject matter jurisdiction over the debtor's debts. Well, first of all, because in turn, the applicant is a company within the meaning of Section 210, and that we have also demonstrated the requisite sufficient nexus to jurisdiction. Third, Your Honor, we had set out earlier in the submissions the fact that parties should not be able to relitigate matters at the sanction stage that have already been determined by Your Honor at earlier stages. So we set out the legal principles there. At previous stages, in particular the convening stage, Your Honor had already been satisfied that creditors were appropriately classed in a single structure, in a single class. Second, that the deed poll structure and substantive consolidation framework utilized under our proposed scheme are appropriate. And third, that third-party releases in favor of Mr. Flex Young, as well as in favor of the other debtors, which are the other companies in the group who had applied for moratorium protection, were also were appropriate and justified in the circumstances. The next point, Your Honor, at paragraph 41, subpara 2, is that to date there's been no complaints or objections on these points following the convening application, with the one exception, of course, of Parastate's appeal, which had been withdrawn. Your Honor, we put in our submissions that no objections have been filed by creditors since the filing of the present sanction application. We've since been told that 2 creditors intend to oppose the application and are here today, but I don't, to date, see any suggestion that they're going to make submissions on any of these. Next, Your Honor, at paragraph 42 of my submissions, we talk about the disclosure of information to creditors, and we submit that we have given sufficient information to ensure that creditors are able to exercise their voting rights meaningfully. At the risk of repeating things which I've said before, we had, prior to the scheme meeting, already provided, first of all, the full scheme. Secondly, the detailed explanatory statement. In fact, creditors had complained that the explanatory statement was too long and too detailed. That was the objection which was raised. Obviously, I disagree, but that was the objection raised before you at the previous hearing. And the reason why it was so long and so detailed was because we had included in the explan the financial advisor's analysis of the relevant alternative, which in this case is insolvent liquidation. We had given details of the key terms of how the scheme was going to be implemented. We had set out the material interests of directors. Most importantly, at subpara D, we had explained numerous risk factors that the scheme creditors should consider in assessing whether to vote in favor of the scheme. So Your Honor will recall at the previous hearing, a creditor, I believe it was Parastate, raised issues with perhaps how uncertain the concept of issuing another token, sort of the new Babel entity issuing another token as a form of scheme consideration was. We had disclosed those risk factors fully and frankly to all scheme creditors before they had voted. We had also disclosed unaudited management accounts of each debtor And on the next page, you will see we had also disclosed the full form transaction documents to be entered into. So this included the new money documentation for injection of capital, and the other documentation which would set up essentially what I would refer to it in a shorthand as a Babel 2.0 entity to continue the business going forward. The supplemental X plan gave even further disclosures. Yona, I had just described this very recently in the very recent moratorium extension application, so I won't go through that again. But it is set out in some detail in these sections. Yona, I think the simple point to be made is that I believe the company has given sufficient financial disclosure to satisfy the legal test and to make sure that scheme creditors have the best information possible in the time available before the scheme. The very final point I will make, Your Honor, I believe I've already made the point about the voting majority. The final point I will address, Your Honor, will now deal with the procedural irregularities.
Yes.
Your Honor, we have disclosed, in fact, at paragraph 57, which is where I will start. We had been very upfront. I don't think any creditor had raised these issues before we did. We disclosed at the outset that an inadvertent omission had been made in complying with Regulation 3 and Regulation 7 of the proof of debt regulations. First, the chairperson had inadvertently omitted to circulate a list of creditors who filed a proof of debt for voting purposes within 7 days after the proof of debt submission deadline. So they were supposed to have done that by the 23rd of October 2023. Now, we should also say that that inadvertent omission was partially remedied by the fact that the scheme managers did circulate their adjudication results. Your Honor will recall earlier in this hearing, I went through in some detail what those adjudication results were. But the big points here are, first, it contained the names of all creditors who had filed a proof of debt, and second, it contained the amount claimed under each proof of debt. So, Your Honor, these details, essentially the list of creditors requirement was omitted, but partially remedied shortly later, 23 days late, albeit, but still 1 month ahead of the scheme meeting. Now, Your Honor, subparagraph 3 is important. The adjudication results do contain some of the details required in a list of creditors under Regulation 3, but it does not contain the address of each creditor, and it does not contain a brief description of the nature of claim. But what we have asked the scheme managers to do since then is to rectify that as expeditiously as possible. So within a very short amount of time, days, within days of discovering their error, they have since then circulated the list of creditors with the details required. Your Honor, my simple submission here would be that I don't believe any creditor has raised objections on this basis. I also don't believe that any creditor has been prejudiced, nor has anything of the like been suggested. However, if the court is so minded to, we have sought prayers for the court to remedy or to grant orders remedying this irregularity as well. And that was the prayers that for a declaration that the non-compliance with the POD regulations does not invalidate the scheme meeting. Your Honor will see we've turned now to page 1 of my written submissions just to show Your Honor the summary. This is at page 1. We've sought a declaration that the non-compliance with the POD regulations does not invalidate the scheme meeting. We've also sought further or alternatively an order that the period for the scheme chairperson to comply with the POD regulations be extended to 4th January or such other day as the court may determine. 4th January is the date when they remedied this. Your Honor, in this case, the person who made the mistake, to be frank, is not even the scheme company itself. This was Deloitte. Unfortunately, it was Deloitte's Hong Kong office If I may respectfully suggest that perhaps that's why they weren't quite so familiar with Singapore law requirements. But Your Honor, nonetheless, I would submit that they are insolvency professionals, that there can be no suggestion that they made this mistake, anything but honestly. So Your Honor, if Your Honor is with me, I would also ask for a declaration that these irregularities be cured by the court in the form that we have asked. Lastly, Your Honor, I will turn to paragraph 81 of my submissions.
Yes.
Your Honor, this is the final element, I suppose. Your Honor, I would submit that this is an arrangement which an intelligent and honest business person would reasonably approve. We've given you the figures excluding the related party creditors at paragraph 83. I believe this significantly exceeds the requisite statutory majorities. And I would just submit that the creditors in this case have cast their vote. This scheme should pass. And I would humbly ask for an order in terms of the application. Your Honor, I'm ready to address Your Honor on any other point I may have missed.
Even on the strictest measure of what counts as related parties, you would have crossed the threshold, correct?
Significantly, yes.
Mhm.
So, Your Honor, we gave you those permutations at page 20 and 21. That by any of those three measures, we gave you three permutations. If you exclude all of them, if you exclude only the two who we say are related party creditors, and if you exclude only the ones who voted in favor but include the opposing one, on any measure, Your Honor, we would pass this test. That is page 21, paragraph 52 to 54.
All right. But I do note that in communications reports, it was indicated to us that Quantum Return and Strong Media opposed, but they're not seeking to make arguments this morning. But I will, for the record, just take note of their opposition.
My apologies, Your Honor. I saw that Quantum gave that indication. I wasn't so sure about the second.
That's all right. We were informed orally this morning.
Okay, thank you. Yeah.
No legal arguments are coming in. All right, thank you. All right. So having had the submissions and considering the affidavits and looking at the requirements, taking even the strictest measure, the related parties, I'm satisfied that the required statutory majorities have been met in the vote. I'm also satisfied that other requirements under the law have been met. As for the irregularities, I do not see any prejudice or substantial injustice arising. Thus, in the circumstances, I see no reason why the orders prayed for should not be granted. So accordingly, in terms of the summons, I will grant order in terms of. Sorry, could you for the record state what exemptions require the 210(6) and why? Mr. Yeo?
Your Honor, that is the requirement for companies to essentially put the whole scheme into their constitution. Your Honor, I don't believe that should be required in this case. I believe scheme creditors would know about the scheme. It has been very well publicized. In fact, videos of these proceedings have been on YouTube and have been reported on.
All right, so no practical necessity for this. All right, thank you.
Thank you.
All right, so accordingly, I will grant order in terms of paragraphs 1A and B, C for the declaration, and E for the liberty to apply. All right.
Much obliged, Your Honor. There is nothing further from me except to thank Your Honor and the court
All right, thank you.
for the time.
All right, thank you.
My apologies, I believe Mr. Chan wishes.
Sorry. All right, thank you. All right. All right, thank you all. I had taken that there were no other objections from anyone. All right.
Your Honor,
Yes, Mr. Chan.
just to thank Your Honor. Sorry, just to thank. Sorry, I need to.
There's a bit of an echo.
Your Honor, just to thank Your Honor, but also to, if it's appropriate for Your Honor to write, because this particular decision in terms of the deed poll, in terms of substantive consolidation and what have, this is probably the first time it's been sanctioned by Singapore court. But just a request, if Your Honor will so indulge, I'll be prepared. Grateful, Your Honor. And thank you, Your Honor.
All right, thank you. I cannot promise a judgment. I have a few things I need to write before then. All right, but I'll see what I can do. All right, thank you.
Your Honor, my apologies. There was one final thing, which is my client was due to give financial disclosures by yesterday. That is Sunday.
Sorry, there's a bit of an echo or feedback. Could you repeat?
My apologies, Your Honor. My client was due to give financial disclosures by yesterday, pursuant to section 64(6) of ADA. Your Honor, that would probably be the final set of financial disclosures. This was ordered pursuant to Your Honor's previous moratorium extension.
All right. Yes.
We didn't give it by yesterday. My apologies, Your Honor. That's because it was a Sunday. My client has undertaken to give it by today.
All right. So financial disclosure may be sent in by today. Right.
Yes. Thank you, Your Honor.
All right. Anything else from anyone? If not, all right. Thank you.
Thank you.
Good day. Court is adjourned.
Court is adjourned.